First case to come before the court today is State of Ohio versus Matthew Glaze. And you each know that you have 15 minutes to present your arguments, and you may reserve up to 5 minutes. Just please let me know.
I would reserve 5 minutes.
Thank you. And I just remind everybody, because so I get in the habit of saying it, that if there are ever any children involved, please don't refer to them by name.
Yes.
Thank you. You may begin.
Good morning, Your Honors. Giovanna Bremke on behalf of Mr. Matthew Glaze. I apologize for my voice. I've been sick and the weather hasn't helped it. But
I think everybody sounds a little froggy.
yeah. So if you can't hear me, let me know. This case involves, and it's lengthy. You'll see because of the assignments of error that I've raised. The transcript's lengthy, and it was a multi-week jury trial in front of Judge John Maraldi. It was a 17-count indictment with 2 supplemental indictments involved. It involves a car accident on the corner of 113 and 58 Amherst Township. I would like to start the assignments of error a little bit out of order, but with the expert in the Dauber hearing. So the assignment of error is that the judge allowed for the expert, Dr. Wyman, to testify about the dysphoric effects. And again, there's a lot of scientific terms here, so forgive me, but about the dysphoric effects of cocaine. Dr. Wyman actually issued 2 reports. The first, he was under the assumption, the faulty assumption that we were dealing with a blood test, and his conclusion was that there was binging, meaning major cocaine use. When really what had happened was there was a blood test that showed no cocaine, and there was subsequently a urine test that showed, and I'm going to refer to it as BE because it's a long term that's in the transcript, but it's basically cocaine metabolites in the urine. So he, because obviously there's number differences in urine and blood, he originally said that there was binging in the cocaine use. Then came back and said, when he realized the error and that it was urine, and said actually there wasn't binging at all, and that it was essentially a trace amount of cocaine or a metabolite of cocaine. So that causes a dysphoric effect. So the judge realizes the Fry standard, which came before Dauber, on whether the evidence is generally accepted. Dauber says whether it's relevant and reliable. The issue is Dr. Wyman relies on Ishmael, an article in the Forensic Science Review in 2002. It's a 16-year-old article. He testifies that there's no additional resources that have relied on this Ishmael test, and to say that the dysphoric effects would cause a reaction in order for the reckless element of this.
Now, did he opine on the heroin?
The opiates were prescribed opiate.
Well, but there was also heroin found in the pill vial.
I don't know, in the pill, yes, but there wasn't, his testimony was as to the BE metabolites for the cocaine.
So he was just addressing the cocaine.
Right. And also there was a lengthy talk, and I cited in my brief about evidence rule 702C, which the judge struggled with whether Dr. Wyman hadn't actually done the test himself, so he relied on these results, and whether 702C requires that there's an experiment or a test done. And if you look at 702, A, B, and C have to all be applicable. A and B, there's not really a doubt there, but C, there is. And to go into the manifest weight and sufficiency, again, it kind of goes into this BE and the metabolites. The sufficiency argument is that there wasn't sufficient evidence as to recklessness, which essentially is the intoxication in this case. There was a lot of, and the defense does a good job at eliciting testimony about how drugs affect your system in order to establish that intoxication and that recklessness. So there's ingestion, either orally or through the skin, something along those lines, and it's then gone into the blood system. It's dispersed through your system, and the high happens when that blood containing the drug gets to the brain. In this case, the blood didn't show any cocaine. It didn't show any drugs. So that means after the drug goes to the blood system, it's discharged through detoxifying organs, meaning urine, skin, through sweat, or some other way. So it was shown in the urine, and the significance of that is it was on its way out, the high, and actually Dr. Wyman had testified that, I believe it was on transcript page 559, that a cocaine high lasts 10 to 15 minutes. So, and that's when, again, the blood hits the brain. The high was gone, therefore, the recklessness was not there.
But wasn't there about a 2.5 hour gap in time between the time the alleged ingestion occurred and the time the urine was taken?
It was actually, I don't know the exact amount of time, but there was a DRE, drug recognition expert, that went directly to, Mr. Glaze went to the Amherst ER, and he was there almost directly when Mr. Glaze had gotten there shortly after. It wasn't, I don't know if it was 2.5 hours. I'm sure it wasn't immediate, obviously, because there was some transportation to the ER.
There was some evidence put on as to the gap in time between the time of the accident and the time this stuff was, the urine test was taken, right?
I'm sure there was. I don't know the exact time. And again, I would assume that there's some time because of the transportation. Regardless, it would be the state's burden to prove that and again, it's scientific, but it's my understanding that that urine, it doesn't immediately go out of the blood. You can have a blood test and show cocaine within that 2-hour period. It's not immediate that it would go to the urine. So if it was used directly prior to the accident, it would have still been in the blood. And again, the point is, once it's in this BE form, which is a metabolite form, the high is no longer there. And the state relies on the expert of the dysphoric effects, which is basically the coming down from the high, to say that that's recklessness. Mr. Glaze did suffer from what's called syncope, which is essentially a scientific fancy word for fainting. And regular fainting, he had seen his doctor months prior and disclosed the syncope. The doctor didn't say you can't drive, didn't put any restrictions on him as far as that goes, and so again, that's not recklessness because he wasn't told that he couldn't drive.
Well, so the syncope, that's passing out, is what the evidence was.
Correct.
Okay. So when he was observed by the police officers as not passing out, but just being very, very like lethargic and so forth, sound like almost a narcolepsy, which there's no diagnosis for, right?
No.
In this record.
So I would like to touch on that, because that goes to my manifest weight and the credibility of this DRE. And again, I outlined in my brief when Mr. Glaze had gotten to the Amherst ER, which is, he actually wasn't even able to be medically cleared at the Amherst ER. He had to go to an Elyria ER because of his significant medical issues. He has diabetes, which also could be contributed to these passing out episodes, the syncopal episodes. He had a heart condition that sent him to the Elyria ER. He obviously had trauma and shock from this accident, and the DRE, regardless of all of these 11 diagnoses, the shock, the trauma, the accident that just happened, still goes forward with these tests And the credibility of that it's not credible because of the fact that, again, the DRE is not medically trained. He's a trooper that had, I think like a weekend class of, in addition to his other training, DRE training, and he doesn't take into account these medical episodes, the medical testimony, and the diagnoses. And again, Mr. Glaze was in such poor condition that he couldn't even be cleared by the smaller ER, and he had to be taken to a different ER because of all of these diagnoses. And the diabetes is also significant, and that was a prior diagnosis prior to this accident.
Counsel, you're into your rebuttal time if you.
Okay, let me just briefly touch on the consecutive sentences, and again, this is a touchy subject and I don't want it to seem like it's insensitive, and it's not coming from my client but from me, that the 18CA011289 there's this general finding, and then also you have to find, the judge has to find one of the A through C factors. One, that he was awaiting trial or out on bond while this happened. 3, that there's a criminal history. Neither of those apply. He had 44 years old and no prior criminal history. And the second, that there was multiple offenses and great harm. And again, I don't want it to seem insensitive, but it was an awful accident, and no one disputes that, and that these 2 ladies had passed away. But it was one incident on behalf of Mr. Glaze that, or one episode that had caused all of the harm, and it was nothing, even if there was one person in that vehicle, it would have still been the same actions on his behalf, and therefore consecutive sentences are inappropriate.
Counsel, I'm just thinking, if somebody throws a bomb into a building, there might be one person in there, there might be 100 people in there. There might be one person that dies, there might be 100 people that dies.
Correct.
So what's the difference?
Well, it's not intentional in this case, it was an accident, and that makes a difference with the intent as far as if you're throwing a bomb into a building where you know there's multiple people, that takes into a different mindset.
Was he driving with the suspended license though?
The suspension was, yes, but as a result of, it wasn't like again, he doesn't have a prior criminal history, I think it was an unpaid speeding ticket or something minor. I'll reserve the rest.
Thank you.
Good morning, Your Honors. May it please the Court, Lindsay Paprocki on behalf of the State of Ohio. Glaze initially argues that the evidence was insufficient and against the manifest weight of the evidence to support his convictions for aggravated vehicular homicide because he was not reckless in causing the deaths of the 2 female victims that died in the automobile accident. He argues that he was not intoxicated at the time of the crash, partly because he was suffering from this syncope, and in his brief argued that he had a concussion. The evidence at the trial simply defies this argument. Initial test results for Glaze's urine from the emergency room revealed a triple positive result for benzos, cocaine, and opiates. The blood work was negative for illegal substances. Glaze's urine sample was then analyzed by the toxicology lab at the Ohio State Highway Patrol, and the lab report confirmed positive results for cocaine metabolites, or BE, and positive results for the presence of morphine. Again, no results for drugs were detected in Glaze's blood. Glaze argues that he was not intoxicated and therefore not reckless because his blood was negative for the presence of drugs and his urine only showed BE. He submits that he was therefore no longer feeling a high from the cocaine. In making this argument, Glaze wholly ignores that his urine also tested positive for morphine. There was testimony at trial that morphine is an opioid, which can be given as a pain relief compound, but it is also in the metabolic path of heroin, which means that heroin essentially breaks down into morphine. The state's toxicology expert testified that because heroin metabolizes so quickly, it is rarely ever detected in a person's blood. However, the presence of an opioid in Glaze's urine was completely consistent with the testimony of multiple witnesses who observed Glaze after the crash and detected signs of impairment in Glaze, which included pinpoint pupils, his going on the nod, his slurred speech, and those are all indicators, hallmark indicators, of someone who is impaired with an opiate. The combination of these observations led the DRE and Dr. Wyman, who did opine in his report that Glaze was under the influence of an opiate at the time of the crash and was unable to operate a vehicle safely. In arguing that Glaze was also not reckless, he ignores the other testimony in the record that he was driving under a suspended license, the testimony in the record that he was driving at a highly excessive speed when he crashed into the Chevy Cruze, the testimony in the record that he drove left of center when he was intending to drive straight at the intersection, and that he was driving with worn down brakes, which he never applied before striking the Chevy Cruze. Further, there was evidence at trial that a prescription pill bottle containing heroin residue was found just outside of his vehicle, and that a crack pipe containing cocaine was thrown into the bushes. As to the issue of the syncope, Glaze's doctor testified that 8 months prior to the crash, he was diagnosed with near syncope, which causes you to feel faint but does not cause the loss of consciousness. Here, the emergency room doctor, Dr. Morris, who is also a board-certified neurosurgeon, testified and noted in her records that Glaze did not suffer a loss of consciousness as a result of the crash, and as a result did not diagnose him with a syncopal episode. She did diagnose him with 11 other diagnoses, and it's important to note that one of those was a polypharmacy-induced altered mental state, which was based on the triple positive toxicology screen. Dr. Morris also noted that although she diagnosed Glaze with a concussion, that concussion was not caused by the altered mental state. Instead, Dr. Morris noted that Glaze had an altered mental state in the setting of that positive toxicology screen and a negative CT scan, which meant that the altered mental state could only have been from the polypharmacy or the mixture of drugs in his system. And also as to the DRE was medically cleared to perform the tests, which he performed on Glaze. That's important to know, because as to his credibility, those tests were authorized to be performed by the physician. He would not have conducted the DRE examination if he was not authorized to do so. Also, as to Glaze's admission into the Elyria ER, the doctor was also clear that that admission had nothing to do with any brain injury. It was related to elevated levels of, I think, troponin in Glaze's blood and for chest pain issues. As to the third assignment of error regarding the state's experts' testimony as to the dysphoric effects of cocaine and whether that testimony was scientifically reliable, we would submit that the trial court properly admitted that testimony. As we've heard, the dysphoric effects of cocaine are also commonly referred to as a crash, and Dr. Wyman testified that fatigue, drowsiness, paranoia, and anxiousness are related with such dysphoria. He testified that it's a common phenomena that toxicologists are aware of and that it has been written about in scientifically peer-reviewed articles and has been spoken about in relationship to impaired driving. He also testified that he derived his opinion based on his training and scientific literature, and one of those scientific peer-reviewed articles was the article by Dr. Eisenschneid, which discussed the negative effects of dysphoria and the results of dysphoria on impaired driving. He testified that this is a classic peer-reviewed article and that it is not been subject to any criticisms. This was at the examination of the counsel and the trial judge in this matter. Dr. Wyman did produce 2 expert opinions for the state. One was clarified after he had mistakenly indicated that he believed that the cocaine was found in Glaze's blood, and then he clarified his report, and he did indicate that in addition to the effect of the opioid, Glaze may have been experiencing dysphoria. So he did conclude, however, that Glaze was under the influence of opioids at the time of the crash. So he did author an opinion as to the heroin. We would submit that the Dr. Wyman's testimony was properly admitted for trial because the standard for reliability is a flexible one, and the court has considerable leeway in determining how to measure reliability. That was cited in my brief to case law by this court. As to the imposition of consecutive sentences, we would submit that the court made proper findings to impose consecutive sentences in this case. The court ordered counts 1, 2, and 3 to be served consecutively. It made a proper finding to do so after finding that there were 2 or more offenses committed. Multiple offenses were committed. The statute does not require that 1 or more course of conduct be committed. It merely requires multiple offenses be committed. And although Glaze may have only driven his vehicle into a single collision on Route 113, that conduct resulted in the death of 2 women and the serious injuries to 2 others. While the state proceeded against Glaze for offenses arising from a single course of conduct, a 17-count indictment followed. The offenses for which Glaze received consecutive sentences involved separate victims who were each entitled to a separate sentence. Because the trial court did make proper findings under 2929.14C, it properly imposed consecutive sentences upon Glaze. The state would submit that the trial court's decision should be affirmed in this matter.
Thank you. You have 2 minutes and 52 seconds.
Great, thank you. I did want to point out 2 different areas in the transcript where there is talk about these prescription opiates, and that's transcript 467 and 946. It was prescribed Xanax and oxycodone. The morphine metabolites, again, there was argument that that is a result of the prescription opiate use, which would be as prescribed. And it was, the state largely argued, although there was talk about the morphine, it was largely that this BE and the dysphoric effects were the result of the recklessness, which is obviously the element for ag vehicular homicide. Any questions? I also have the disproportionality argument. Again, I was here maybe a couple weeks ago making the same argument, and I think that that's important because the standard and what the case that I've cited says, if this is a sentence that shocks the community, and again, the reason that I keep raising it is because in the same exact courthouse, you have Chase Johnson, who is a defendant who was in a car accident and killed a young woman he had marijuana in his system and only received community control. Adriana Young received 4 years and was released after 6 months, again, killed a mother holding her infant child in her home, was also using marijuana. There is a huge issue with disproportionality, and guidance would be appreciated, I believe, by the trial court judges. Thank you.
Thank you. Thank you both for your presentations to the court. The court will take the matter under advisement and issue a written opinion that will be sent to both sides and also released on our website, which is released on the Supreme Court website. Thank you very much.